Also, I look at the allegations, recognizing that they certainly are allegations, and usually I get one side of the story, so I don't get all of the facts. I just get enough to ensure that the elements of the crime are met. So with that being said, I do have some concern for the safety of Miss Birch, and I do understand that two children were present during this altercation, alleged altercation. So I have concern for their safety as well. So what I am going to do is I'm going to order a 2,000 PR bond. Okay, there are conditions of your release. First of all, you are not to miss any court dates. You're not to violate any state or local laws while you're on bond. You also are not to possess, purchase, or consume any alcohol, controlled substances, or marijuana. Also, you're not to possess or purchase any firearms, ammunition, or dangerous weapons, and you are not to leave the state of Michigan without permission from a court. Also, you're not to have any contact or assaultive behavior towards, towards Sasha Brayman. That means you cannot have any contact at all towards her. You cannot call, write, page, email, text, no electronic communications of any kind. Can't have any third parties contact her on your behalf, and no threatening, harassing, molesting behavior towards her or anyone else. And you may not go within 2,000 feet of where she lives, works, or goes to school. That means if she calls you on the phone, you hang up. If you see her in the grocery store, at a gas station, whatever, you turn around and walk the other direction. Absolutely no contact towards her, or well, I'm going to back up a little bit. No contact at all towards her. Now, in regards to the children identified as Jasmine and Landon, the court is simply going to say no assaultive behavior towards the children. Okay, that doesn't mean that you can't have contact with them, but no threatening, harassing, molesting towards the children, no abusive behavior. No, absolutely, if there is any allegations of violence towards the children, then that would be a violation of your bond, and certainly could result in a maximum penalty of up to $7,500 fine, and or both 93 days in jail. You understand that, Mr. Birch?
Yes, ma'am.
Okay. All right. Anything else? Well, I do have one other thing. Let's take care of that, and then I'll let you address bond, Mr. Harris. This final condition, sir, is as follows. One of your bond conditions prohibits you from purchasing and or possessing any firearms while this case is pending. You are required to surrender any firearms and or CPL. This includes firearms located at your residence or any other location accessible to you. This is not optional. You must file a verification form with the court within 2 business days, stating either that you do not possess any firearms or that you surrendered all firearms. If you need to surrender firearms, you must contact the Firearms Relinquishment Unit at the district court for the steps to safely and lawfully surrender. You will be given information about how to contact the Firearms Relinquishment Unit and the verification form when you are released. That information was just provided to you by the detention officer. So there'll be a phone number on that for you. Additionally, this bond condition does not give you permission to return to a no contact location to retrieve a firearm for purposes of relinquishment. Failure to comply with any condition of pretrial release is contempt of court and may result in bond revocation. Do you understand, Mr. Birch?
Yes.
All right, then. Anything else for the record, Mr. Harris?
Your Honor, I would simply like to put on the record that the defense objects to this bond condition because it may likely violate the First Amendment by compelling my client's speech, as well as potentially the Fifth Amendment protection against self-incrimination.
All right, duly noted. Thank you. All right, Mr. Birch, you're all set. That concludes your arraignment. Well, let me say one more thing. If you have property at that location, you cannot go there. So you can have someone else pick up your property, whatever that may be, but they're not to talk to Ms. Brayman, and certainly they're not to talk about this case at all. They're just there to get your stuff and move on. And in regards to where you're going to stay with your parents, you will have to call the public defender's office. The officer in the back will provide you with a phone number to call. They may be closed when you call. You have 24 hours from now to do that. All you have to do is leave your name, your phone number, and your address, and you'll be fine. Okay, questions on that?
Nothing from the defense,
What
Your Honor.
exactly did you mean by a 2000? Okay, never mind.
No, I don't have a problem. So basically 2,000 feet, if you go within 2,000 feet, just think of a big old circle around where she lives, works, or goes to school. You cannot enter into those zones, because if you do, that's a violation of your bond. So if you normally go through that area, don't do it. And if you're cautious, make sure it's more than 2,000 feet. Make sure it's more than, maybe it's a mile or 2 miles. Okay, but no, you can't drive in those areas. Do you understand that?
Yep.
Okay, all right. Then you're all set, sir. Thank you.
Thank you.
You're welcome.
So he's leaving soon, right? He's gonna be leaving soon.
Not till we get paperwork. No paperwork till after you're all seen.
Add those.
We have to keep it
Right.
in the bag out there and I would think to but they'll probably through so fire out there, but they'll be able to where they're on. We should be able to use that right there.
Yeah. That's what I'm worried about. Because I don't have anybody out there to talk to.
Will you look up their last names for me on the kids? I didn't look to see what that last name is, but I do have the first names in there. All right, Jeffrey Scherberger, please.
Hello. Sorry, my hairdo's all not the best.
All right, good afternoon, sir. Are you Jeffrey Daniel Scherberger?
Yes, ma'am.
All right, thank you. And Mr. Harry's, your appearance, please.
Yes, Your Honor, Assistant Public Defender James Harris here on behalf of Mr. Jeffrey Scherberger, who is here for arraignment. He has requested the services of the Ingham County Public Defender's Office. So we would request that a not guilty plea be entered on his behalf at this time.
All right, thank you. All right, Mr. Scherberger, this is file number 26-01613SM. This is a complaint in the people of the state of Michigan versus Jeffrey Daniel Scherberger. That's Scherberger. It is alleged on or about June 15th, 2026 at 5723 South Martin Luther King Boulevard, City of Lansing, Ingham County, Michigan. Count 1 alleges that you did enter with or without breaking a house located at 5723 South Martin Luther King Boulevard in Lansing, Michigan, whether occupied or unoccupied, without first obtaining permission to enter from the person having immediate control thereof. Contrary to law, sir, that is a misdemeanor, maximum penalty 90 days and or $500. Do you understand the charge and the maximum penalty?
Ma'am,
All right, and you have rights as well, so we're going to go over those. You have the right to plead guilty, not guilty, or stand mute. You have the right to a trial by a judge or a jury, and at that trial, you can present or confront witnesses. If they would not appear, sir, the court can order them to do so. You also have the right to a lawyer, and if you cannot afford one, one can be appointed for you at court expense. Additionally, you are presumed innocent, and if you are found guilty, it must be beyond a reasonable doubt. Do you understand those rights, sir?
yes, I do.
Okay, now the court will enter a not guilty plea on your behalf. And you have a pretrial date scheduled for Monday, June 29th. That is at 9:30 a.m. with Judge Flores. And you may appear in person or by Zoom. If you have access to Zoom, that's great. But if you do not, then you must appear in person. Do you understand that?
Yes, ma'am.
Okay, and do you have the notice to appear and the Zoom instructions?
Yes, ma'am.
Okay, good. Hang on to that. Now, is there anything I've told you that you do not understand?
Not at this point, no, ma'am.
I would ask if the court would permit a third party to go and pick up his belongings to avoid any concerns with the no contact order. Other than that, I would simply request the court issue a PR bond at this time.
Okay, so my understanding then from what you've said is that Tashay Riley, the alleged victim here, the complaining witness, is simply a neighbor, there's nothing beyond that. Is that right, Mr. Harris?
That is my understanding from Mr. Scherberger.
Okay, but you asked for a third party contact with the neighbors?
Well, no, a third party my understanding is I believe his vehicle and some personal belongings is at the property he was staying with his ex-wife. And him going to that property would likely put him within 2,000 feet of the neighbor's home, which could be considered a violation of the no contact order if one is issued with the neighbors. I simply wanted to request that in case the court was going to issue a no contact order with the neighbors.
Okay, well, at this point, I don't, and I appreciate all that additional information, Mr. Harris. It appears in the affidavit and claim that there was no assaultive behavior in this. So I'm not going to order a no contact order. So in regards to your ex-wife, I you said that you're tired of working on it. I don't want to hear anything beyond that. I'm not going to say that you can't have any contact with her because I don't have anything before me that says that she is an alleged victim or a complaining witness that I have any concern. So at this point, I am going to grant you a PR bond, and that's going to be a $750 PR bond. The conditions are as follows, sir. Do not miss any court dates and do not violate any state or local laws while you're on bond. You are not to leave the state of Michigan without permission from the court, and you are not to have any assaultive behavior. That's towards anybody, whether it's whomever, just no assaultive behavior at all. This does not prevent you from going to get your belongings, but you have to remember for sure that no assaultive behavior. So if you find that it's better to go at a certain time of the day when the neighbors aren't home or whatever, just don't have any conversations with them. Just get your stuff and move on from there. Do you understand that?
Yes, ma'am, that's my plan. Go get my stuff and dip. I don't want to be around that. I worked too hard to.
Okay. All right. The other part of this is obviously we have an address on Lake Lansing Road in Charlotte. You'll have 24 hours to get the information of that valid release address to the public defender's office. The detention officer in the back will give you a phone number to call. They may be closed, but all you have to do is just leave your name, your phone number, and the address, and then you'll be fine on that. Does that make sense, Mr. Scherberger?
Yes, ma'am.
Okay. All right. Anything else for the record, Mr. Harris?
Nothing from the defense, Your Honor.
Okay, I've got one other thing, sir, that is a handicap parking matter. And then the last file I have is a civil matter, Mr. Harris. So you're all set. You are free to go, sir.
Thank you, Your Honor. Have a good rest of your day to you and your staff.
You too. Thank you. So, Mr. Scherberger, this is ticket number TU 240-33794. It is a handicap parking zone that was on Collins Road in the city of Lansing, Ingham County, Michigan. The vehicle was described as a Kia. Last three digits of the vehicle are 24, B as in boy. That was issued on July 25th of 2024, almost 2 years ago. And it looks like we tried to send you notices. We mailed that out to an address in Battle Creek, and they all got returned to the court. Do you remember getting the ticket?
I remember that. And then I thought I squared it away. I thought I had a understanding between me and the person who gave me the parking after I called them up. I'm a disabled vet, and I got a disabled veteran plate on my vehicle, that one and my current vehicle. And there was no understanding whether I couldn't park there or not. I mean, it's for handicapped individuals that are disabled, and I was thinking I was taking advantage of that. Come to find out, that was a no bueno. But apparently, I didn't have a circle with a chair on it, which was news to me. So
Yeah.
I thought it was solved and taken care of. So I apologize.
Okay, so it does have a balance of $198. Let me tell you a little bit about disabled veterans plates. They are not necessarily the handicapper plates that are reviewed by your physician and then given by the Secretary of State. I absolutely appreciate your service, and it is it's not great that you're disabled, but what I will do at this point is I will reduce this by half. So if you want to use a handicapper space, you'll have to talk to a physician. And if you can meet the conditions that are listed in that handicap in the law, then absolutely you'll get that. And you can either get a placard or a plate. That's up to you to decide. But if you really want to park in handicap parking or you need that, then contact your physician. Okay.
Yes, ma'am. And I appreciate that.
Okay. All right. So I'm going to reduce that to half of 198, which is $99. And you'll have 30 days to pay that. So that'll be an extension to July 16th. All right.
Yes, ma'am.
All right. You're all set, sir. That concludes your arraignment.
I appreciate you.
Yeah, you're welcome.
Yeah, well, I got supposed to get it right.
Yeah.
I'll say something, okay.
All right. Last but not least, David Bermudez, please. If you could stand up closer to the table, that would be very helpful. All right, thank you. All right, so you are David Bermudez Jr., is that correct?
Correct.
All right, thank you. All right, so this is file 02-03205G2 GC. So this is a motion, affidavit, and bench warrant on LAPQ as the plaintiff and you, sir, as the defendant in a civil matter. It is issued because you failed to appear for I guess it was a show cause, but for a show cause hearing after a bench warrant. You were supposed to appear on March 25th of 2024. You didn't do that. Why not?
Well, my mother had passed away in 2024, and I was probably just going through a lot with that. There's really no excuse.
Okay. All right, so you have a new date now to appear, sir. That let's see a date here. Now that I'm looking at this, you do have a show cause after the bench warrant on July 16th, 1:30 p.m. with Judge Flores. you're allowed to appear remotely by Zoom. You should have that notice. Has that been provided to you yet?
The Zoom notice, I'm not sure of. I know I have copies of my notice to appear, but
Okay.
yeah.
Right, well, some of them. Are you still at 1045 West Street in Jackson?
Yes, yeah,
Okay.
yes.
Okay. And is the last four digits of your phone number 3967?
Correct.
Okay. You're in a jumpsuit. Are you incarcerated?
I am. I'm in Jackson County.
Do you have a release date?
I do have it July 8th.
Yeah, I'm sorry. What about July 8th?
My out date's July 8th, if and or rehab comes first for me. I'm not sure with this going on right here between the LAFQ is gonna allow me to go to rehab but if not, July 8th is my out date.
Okay. What was that?
I figure out why he's here today. He had a sentencing with Judge Simmons on a really old felony case.
Okay, you know.
Looks like they gave him time served.
Oh, okay. All right.
And then he must have had this, and they said, well, he's here, so.
Okay. All right. Well, last time I saw you in January of 2024, I gave you a $300 personal recognizance bond. It looks like you owe a substantial amount on that matter. Looks like over $1,100. But obviously you've been incarcerated. How long have you been in Jackson County?
I've been there since March 28th, I want to say.
Okay.
But then I seen you on April 21st, I want to say. I had met with you for a Zoom.
Oh, okay. All right. All right. All right. So at this point, well, it looks like you've missed a bunch of these, and that's the part that I can't do much about. Judge Flores has a 10% bond. So that's going to be 1,000, 10% bond. And if you aren't able to pay that, ultimately you would be PR'd on that since it's a civil matter. So make sure that you show up on July 16th at 1:30 p.m. for your next hearing. Understand?
Yes, I do.
All right. All right. Then you are all set, sir. Thank you. Good luck to you. All right. Thank you, officer.
With that, I would like to make a motion for bond as well.
He's definitely not getting one. Do July 7th at 1:30. July 7th at 1:30. Gonna have to deal with this case in 2026 and been tracking this young man down for a long time. He was remanded because he wouldn't come back to court. He's not getting a bond. That's all set. We'll have that set for hearing on that date.
Oh, sorry, what was the date on that?
It was the 7th of July. This is the matter of the state of Michigan. This is John Heather. 24-01274. Mr. John Heather.
Yes, ma'am.
Okay, you're here today for arraignment on a probation violation. I have a request and summons for probation violation. It says that per PATS, you failed to submit to random your analysis on May 27, 2026, and that you've also failed to obtain employment and provide evidence to your probation officer. So you have the right to have a contested hearing. You have the right to be represented by an attorney at that hearing. If you're found to be in violation of your bond conditions, you can just go ahead and do jail time, okay?
Understood.
Did you want, or did you make a request for an attorney? Did you make a request for an attorney?
I would like to make a, yes, I would like to make a request for an
Oh,
attorney.
I didn't know if he did an intake already. He did not do an intake? He did not. Okay.
No,
Okay, one of the public defenders will log in with you, to meet with you just in just a moment. And we'll set this for a hearing and enter a not guilty plea on your behalf.
Yes, ma'am.
July 7th. Your hearing is July 7th at 1:30 PM, okay?
July 7th, 1:30.
Hang tight, Ms. Straub is logging in now.
Thank you.
And does he have an outdated Department of Corrections?
It's sufficiently far in the future that I'm not certain it's entirely relevant, but I believe there's an additional 4 months on paper.
Okay. All right. So my understanding is that it's as a plea is charged.
Yes, Your Honor.
May I inquire of your client of his advice of rights?
Naturally.
All right. Mr. Zimmerman, you understand you have the following jury trial rights. I'm going to walk you through those, okay? You have the right to be tried by a jury, to be presumed innocent, proven guilty, to have the prosecutor prove beyond reasonable doubt that you are guilty, to have witnesses against you appear at trial, to question any witnesses are brought against you. You are represented today by Attorney Tyler Smith, and he would be present to cross-examine any witnesses or contest any charges brought against you by the people of the state of Michigan. Do you understand that, sir?
Yes.
You have the right to have the court ordering witnesses appear in your defense, remain silent during the trial, not to have that silence used against you, and to testify trial if you choose to testify. If your plea is accepted, you'll give the claim the plea was a result of any promises other than what we've stated on the record, or threats that it was not your choice to plead guilty. You'd also be giving up the right to appeal anything from trial, since you won't be having a trial. You'll be pleading guilty to the domestic violence instead. Is it still your wish today to waive your jury trial rights and plead guilty to the domestic violence?
Correct.
Okay. You're going to raise your right hand as best you can. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes.
All right. I'm going to bring your attention back, sir, to October 20th, 2025 at 1411 Roseneath in the city of Lansing. Were you at Roseneath in the city of Lansing on October 20th, 2025?
Yes.
And who is Haley Yurden to you?
Yeah, ex-girlfriend.
Okay, a former resident, a resident or former resident? All right. And you're pleading guilty to offensively touching Haley Yurden, not in self-defense. What did you do in response to Haley Yurden that makes you guilty of domestic violence in that you offensively touched her?
I grabbed her.
Okay, and that was not done in self-defense?
No.
And Miss Yurden did not want to be grabbed at that time?
No.
Anything towards a factual basis, Mr. Smith?
The people are satisfied, Your Honor.
Mr. Tyler Smith?
I believe that's satisfactory, Your Honor.
I find the factual basis to be knowing, voluntarily, and accurately made concerning this count 1 domestic violence. Mr. Smith, what are we doing here today? I mean, what are we going to do in relation to the plea discharged?
Your Honor, whoever's in the best judicial economy, I don't know how long he's going to be in. If we want to do a PSI, I don't know.
I don't know how probation. I don't know how probation goes and meets with him. So it's 4 months on a 93 day, but that's coming from Mr. Smith. If you can confirm that, then I don't know. I'm not sure.
Would you want to?
I'm willing to take Mr. Smith as his word if you are, but we could go to immediate sentencing, but there's no probation or anything along those lines.
I would make the request for immediate sentencing. Even in a worst case scenario, I'm not certain that the sentence would result in additional time to my clients that would not be prejudicial to him. Also, my client has the right to refuse probation.
Right.
So I don't see that a PSI would be necessary or particularly helpful here.
Right. And the indicated, so to get probation involved, they'd have to meet with Mr. Zimmerman, and they'd probably do that on Polycom, I would think, but I'm not sure.
But to what end? That's my question.
Yeah. So yeah. And then if he's getting day-for-day credit for time that he's in the Department of Corrections, I mean, we're probably not putting him on probation, so he's going to do his 93-day sentence in the Department of Corrections.
Typically, I'd like to run it past the complaining witness.
I think that's fair. I think that's fair to run it past the complaining victim in this matter.
I'd strongly prefer immediate sentencing. I understand it's not something my client can demand.
Yeah.
But regardless of what the complaining victim may have to say, I don't see what impact it might have on my clients.
I don't know, but I think the prosecutor should have the opportunity to speak with Ms. Yurden on it.
Yes, and at least,
And I don't think that it would matter regardless. You know, I think what you're saying is absolutely true. But at least Mr. Smith would have the opportunity to speak with Ms. Yurden
yes,
concerning this matter. All right, so I'm going to let's set for probation review. Ms. Yurden, did you want to say something?
No, not at the moment.
All right, Mr. Smith will be in contact with you, and we'll get anything you say. What we're going to do is set this for sentencing. We're going to have this reviewed by probation. I don't, they may or may not, but we'll hear from Mr. Smith. In the meantime, we'll set this for sentencing, and that may be a date we don't need.
yes.
Yeah.
I will state for the record, if there's any recommendation of probation, my client will be refusing
All right.
to indulge that.
All right. So we'll have probation will probably set up a polycom to see you. Go ahead, Mr. Zimmerman.
As of July 3rd, I'll have 4 months left on a year clock. When I do go home, I'll still be on parole.
Yeah, I don't, so,
Just to shed light on
yeah.
the probation
So-
and parole, I'll
so
still
that-
have a 24-month parole.
yeah.
So we don't need that, but I would like to update the complaining witness, let her know what's going on.
Right.
Let her know what's the next steps, and if she wants to make a statement or anything like that.
Right. Then she has the opportunity to legally make a statement.
She didn't know that this was gonna happen
Right.
today, so I just wanna get.
All right, so you'll be on polycom with probation, and we'll set a sentencing date that we may or may not need for
July 27th.
July 27th at 1:30. All right, Mr. Zimmerman, we'll see you here on July 27th at 1:30. We'll be responsible for the writ. We may not need that date. Okay, that writ might not be going through. We'll wait to hear from Mr. Smith. This may go to just immediate sentencing, and then we can indicate that the time served would be a part of the immediate sentencing.
Yes.
But I think Mr. Smith should have the opportunity to see Ms. Yurden. All right, so we've set sentencing for July 27th at 1:30. Please keep in contact. Mr. Smith will be available to you to keep in contact with. And he'll tell you if we need that date or not, okay? We will be responsible for the writ if needed. I think that's after your date though, right? July 27th, and you've got a 1 year or 2 year flop.
1 year, July 3rd of this year, I'll have 4 months left.
Okay. Oh, so we may not need that date at all, depending. All right. All right. So that's all for the record in 26-00124. You should be all set. We may or may not need that date, okay, for the July 27th date. You should be all set. Thank you.
All right.
Yeah, let's refer him. But what did we read about? Let's see. Let's read about correctional facility.
Okay.
You got sentencing, you can make any statement that you wish, including that one.
I do think the complaining victim has the right to give a complaining victim statement and all that, so.
She does.
Yeah.
Naturally.
Yeah, so. All right,
Anthony Anderson.
yeah, let's go, Mr. Anderson. All right, so we're on the record in docket 26-00981. That is People of the State of Michigan versus Antonio Anderson. Appearance for the record, Mr. Smith.
Thank you, Your Honor. May I please report Assistant Prosecuting Attorney Dan Smith appearing on behalf of the people.
Mr. Tyler Smith.
Tyler A. Smith from the Office of the Public Defender here in Ingham County. I do appear on behalf of Mr. Anderson, who's standing to my right.
And sir, you are Antonio Anderson, is that correct?
Yes, sir.
Right, thank you. This time set for final pretrial in the matter. Mr. Smith, how are we proceeding? Mr. Dan Smith.
Thank you, Your Honor. At this time, again, this was set for a final pretrial. We have reached out to the complaining witness in this case. We have attempted to serve subpoenas on this case. At this time, the complaining witness has not made good contact with our office after repeated attempts to contact her. So the people move to dismiss.
Certainly no objection to that motion, Your Honor.
Right, so this is a dismissal of the request of the people. And so we'll have a nollie pros placed, nollie pros printed out. Based on the people's inability to proceed, the complaining victim attempts were made to subpoena, and she is not, I'm assuming that any contact has been unsuccessful.
Yes, Your Honor.
That should go by first. All right, I do have a GPS monitor on this. So Mr. Anderson, you should probably go back to where you got that, which would be by the jail. And we'll contact the private agency to let them know that you're coming. So they'll anticipate your arrival. And then there is a no contact order with Liana Halliburton. And so you should keep a copy of this nollie pros with you. It takes about 4 hours to purge from the court system. So you should keep this with you. Okay, sir? All right. All right, I've signed the nollie pros with dismissal. Or based on the record reflects the inability to proceed because the complaining victim was subpoenaed and any contact's been unsuccessful. And so we'll make a copy of this and you can keep it on your person, okay? All right, anything else for the record? In 2600981, Mr. Smith.
Nothing from the people, Your Honor.
Mr. Tyler Smith.
No, Your Honor, thank you.
All right, you're all set, sir. Thank you for your appearance today.
Dolores.
Is it Dolores Davis?
Yes.
Okay. All right, so we're on the record in docket 2503078. That is people of the state of Michigan versus Dolores Davis. Appearances for the record, Mr. Smith.
Thank you, Your Honor. May it please the court, Assistant Prosecuting Attorney Dan Smith appear on behalf of the people.
Mr. Tyler Smith.
Tyler A. Smith from the Office of the Public Defender here in Ingham County. I do appear on behalf of Ms. Davis, who's standing to my right.
And ma'am, you are Dolores Davis, is that correct?
Yes.
All right, thank you. This is the time set for a final pretrial in the matter. Mr. Gregory Smith, Dan Smith, how we proceed?
Thank you, Your Honor. At this time, we have attempted to reach out to the complaining witness in this case. We have sent several subpoenas and we have attempted to follow up those subpoenas. We do not have good contact with the victim in this case. In order to proceed, we would need the support of the complaining witness. So at this time, we move to dismiss.
And is that a fair statement, Mr. Davis? All right, Mr. Smith.
That sounds just fine to the defense.
All right. All right. So based on the prosecutor's comments, the prosecutor's unable to proceed, the complaining victim was subpoenaed and any contact has been unsuccessful. We'll grant the motion. We'll grant the motion dismissed without prejudice based on the prosecutor's representations. Thank you. All right, so this case is dismissed without prejudice, ma'am. So the people could reach should they choose to, but realistically, the case is dismissed. You don't have a GPS. You do have a no contact order, so you should carry the nollie pros with you. It takes about 4 hours to purge from the court system. All right, so we're on the record in docket 2601230. People, the state of Michigan
Anything else
versus
for the record
Derek
in
Mason.
250307
We've had appearances for the record.
Nothing
Mr.
from
Smith,
the
how
people,
we
Your
proceed?
Honor. Yes, at
Mr.
this time, Your
Tyler.
Honor, I've
defense, Your
had an
Honor.
opportunity to speak with the defendant.
All right,
and
Ms.
he's,
Davis,
we've worked
I've
out a
signed the
deal on
knowledge
this
possible.
case.
Make a copy for
At
yourself
this
so you can keep
time,
with you, okay?
people,
All right.
would move to amend count 1 to an attempt under the condition that the defendant agrees not to return to 400 Adams Street, Lansing. That's just so.
So it'd be an attempt to be any illegal entry. Right, on the cell phone, in 0297, can you please identify yourself on the cell phone?
Devontae Clark.
Say it again, sir.
Devontae Clark.
All right. Mr. Clark, you're here for your 9 o'clock? Is 750.1152A. And that is a 45-day and/or 250.
Yes. Yes.
And then there is as a part of this, killer agreement of not return to 400 Adams Street.
Yes, sir. Clinton Evans.
Clinton Evans. All right, so we're on the record in docket 26-01148. Is there any other the state of Michigan recommendation and Evans? Appearances for the record. I can, Mr. Dan Smith.
Thank you, Your Honor. May it please the court.
Did you want probation? Take a look at Mr. Adams. Okay. Mr.
Tyler A. Smith from the Office of the Public Defender here in Ingham County. I do appear on behalf of Mr. Evans, who's standing to my right.
And sir, you are Clinton Evans, is that correct?
I'm Clinton Evans the second.
Second, thank you. This is time set for a final pretrial in the matter. Mr. Smith, how are we proceeding?
Thank you, Your Honor. At this time, again, this matter is set for a final pretrial. At this time, the people.
What's how much credit? What's the credit for time, sir?
To believe he spent one day first. Currently charged as an OBI second. We move to amend to OBI first. And it's my understanding that the defendant's going to plead as charged to one count of OBI first.
All right, so we'll be amending. And Mr. Mason, is that your understanding of the plea offer?
Yeah.
All right. One amending. All right, I'm going to walk you through your rights. You're pleading guilty to an attempted B&E while intoxicated. There's an agreement that you not be on the premises. And dismissing the second offense notice of 400 Adams Street. So so any violation of that would end up in a trespass on 400 Adams Street, and then you're getting credit for 1 day jail. Is that your understanding? Okay. All right. And that's your understanding, Mr. Smith. Tyler. So in this misdemeanor plea, you have the right to be tried by a jury, presumed innocent until proven guilty, to have the prosecutor prove beyond reasonable doubt that you are guilty. To have witnesses against you appear at trial, to question any witnesses are brought against you, to have the court order any witnesses appear in your defense, remain silent during the trial, not to have that silence used against you, and to testify at trial if you choose to testify. Mr. Evans, do you understand your rights as I've read to the if the plea is accepted, you'll give the claim plea result of any promises other than we've stated on the record. 93 days and threats was not your choice to plead guilty. You'd also be giving up the right to appeal anything from trial, since you won't be having a trial. You have the following rights pleading guilty, and I'm going to walk you through those amended. You have the right to be tried by a jury, being innocent until proven guilty. Is it your wish today to plead guilty to doubt that you are guilty? Have witnesses against you appear at trial, to question that any witnesses are brought against you. You represent today by Attorney Tyler Smith. You would tell the truth, examine any witnesses or contest any charges at trial. Bring your attention back to, you have the right to have the court ordering witnesses appear in your defense, remain silent during the trial, not to have that silence used against you, and testify at trial if you choose to 400 Adams. If your plea is accepted, you'll give up the claim that the plea results of any promises other than what we've stated on the record. Were you at Mace, was not your choice to plead guilty, you'll also be giving up the right to Lansing on anything from trial. Since you won't be having a trial, you'll be pleading guilty. And at that time, to the first offense, into a house located at 400 Adams Street. And did you do so with your jury trial rights, the permission to be in the house located at 400 Adams Street? Okay. Anything towards a factual basis, Mr. Smith?
People are satisfied, Your Honor.
All right, I find the factual basis to be knowing, voluntarily and accurately made. We'll go to immediate sentencing.
I've spoken, Your Honor, for the record, I've spoken with Ms. Schmitz about any restitution that was required or that she needed in this case. She has informed me that there is not any restitution amount that she's asking.
All right, and so that's Ann Michelle Schmidt.
Yes.
Okay, and then, all right, anything towards allocution in the immediate sentencing, Mr. Dan Smith?
No, Your Honor, again, again, after speaking with the complaining witness in this case, she just has a concern about the defendant being at the property. So again, we've made an agreement. The defendant has agreed not to go back to the property. So again, the people are satisfied with the sentence and the outcome of the case based off of the defendant's assertion that he is no longer going to return to the property.
Mr. Mason, is there anything you'd like to say to the court before the court passes the sentence?
No, Your Honor.
All right, so I will follow the agreement and indicate that the defendant's getting credit for 1 day previously served. This is for, no more jail, okay? And jail, so we'll give it 1 day sentence to 1 day with 1 day previously served for credit. The fines and costs on the matter will be $50 fine, $50 costs, crime victim's right fee is $75, and the state fee will be waived. So that'll be $175 to the city of Lansing. And do you need some time to make that payment, Mr. Mason?
Yes.
All right. So you'll get 90, we'll put you at 90 days to make that payment. 90 days.
I think it'll be September 14th.
September 14th. So it'll be September 14th to make that payment to the city of Lansing. That can be paid online, in person, or at the counter. But you'll have 90 days, so you can kind of make up your own payment plan. As long as it's all paid by September 14th, 2026, that's $175. If you probably want to keep in contact with the criminal division, and that might keep you out of the warrant cycle, because you'll get, if you don't pay, then you'll be show caused, and then we'll issue a warrant for non-appearance, and that's how you stay. That's how you'll get in the warrant cycle. All right. So there's no probation. And then there is an agreement between yourself and the owner of 400 Adams Street that you're not supposed to be at 400 Adams Street. And there will be a trespass letter to that effect. Okay, so if you're there and they want to pick you up because you're not supposed to be there, there'll be a letter to that effect. All right, so it's $175 to the city of Lansing. You have 90 days, September 14th. And as a part of this sentence, you agree not to be on the property of 400 Adams Street, and there'll be a no trespass letter. Anything else for the record in docket 2601230, Mr. Smith?
Nothing from the people, Your Honor.
All right, Mr. Mason, do you have any questions of me? Okay, you should be all set, sir. Thank you for your appearance today.
State of Michigan versus Isaiah Hollins, 26-00999, appearance, please.
Oh, thank you, Your Honor. May it please the court, Assistant Prosecutor Attorney Dan Smith, here on behalf of the people. Assistant Public Defender Joseph Hardy and Mr. Hollins. Mr. Hollins attempted leaving messages last week, yesterday. I checked, he does not appear to be in custody either. Did not see him follow that.
Have a witness here.
Yes, Your Honor. Witness Irma Gomez is currently present and in the jury room. So at this time, given the defendant's failure to appear, we ask that this the bench warrant be issued and Irma Gomez, I think this is yeah, I asked that a bench warrant be issued.
A bench warrant will be issued, and the witness will not be required to appear for any further final pre-trial. Additional matters for the record.
Not from the people, Your Honor. Clear.
This is State of Michigan versus Amadou Mbao, 26-01040. Appearance, please.
Thank you, Your Honor. May it please the court, Assistant Prosecutor Attorney Dan Smith, here on behalf of the people.
Good morning, Your Honor. Jack Rucker appearing on behalf of Mr. Mbao. I've not seen Mr. Mbao in the courtroom today. Was he?
No, he close to.
Is he on Zoom?
No, they said he was running late earlier, so he's supposed to.
He's the one at the vote.
Yes.
For the bus.
Yeah.
Oh, okay.
If the court would pass the matter, we can call it when he arrives, perhaps.
I don't think so.
Thank you, Your Honor.
State of Michigan versus Leon Middleton, 26-00997. Yes.
Thank you, Your Honor. May it please the court, Assistant Prosecutor Attorney Dan Smith, appearing on behalf of the people.
Assistant Public Defender Justin Straub on behalf of Mr. Leon Middleton, who's sitting to my right.
Okay, Mr. Middleton was scheduled today for final pre-trial. Do we have a witness here?
At this time, Your Honor, well, we do not have a witness here. We have reached out to Amber Watts. We've sent subpoenas to her last known address. We made multiple attempts to contact her via telephone. At this time, the people cannot proceed without the complaining witness, so we move to dismiss it at this time.
Dismissed without prejudice. That means the people have the right to reissue that against you. Do you understand that, sir? You have any questions? Okay, we'll get your dismissal in just a moment. Michigan versus Avani Stitt, 25-03584. Appearance.
Thank you, Your Honor. May it please the court, Assistant Prosecutor Attorney Dan Smith, here. People.
Good morning, man. Please, Honorable Court, Kareem Johnson, P number 71988 from Daphne Stitt. Stands to my immediate right.
Okay, I'm assuming the victim's not here.
The victim's not here. I've had multiple contact with her. They are sisters. They
They're
are
co-victims in another case that I have now.
They are co-victims in that case for in the interest of justice.
Which, by the way, would be evidence of a bond violation.
Yeah, so in the interest of justice, we move to dismiss this case.
And I'm not aware of any subsequent cases in terms of any alleged bond violations. We humbly ask this court to allow for the dismissal of the.
We already have a bond violation pending that was set for a hearing today. So for Ms. Stitt to come here when I am well aware that Ms. Straub is representing a defendant whereby the allegations are that this defendant allegedly feloniously assaulted Ms. Stitt and the person that's supposed to be here today. I'm going to reset the bond violations for the day they're supposed to be here for that case. They'll both be here then.
I guess because of the potential Fifth Amendment implications of our testimony, can I be here as well?
You should be, because I'm studying this bond violation. I'm not dismissing the case until I address the bond
Yes, sir.
violation that's been pending, that was set for hearing today. Because what Ms. Stitt's gonna recognize is that when the court gives you an order, you don't violate it.
Yes, ma'am.
Yes, we will reset this matter.
What is that matter set for? July 7th. July 7th. At what time? At 8. At 8 in person at the court. Any additional matters for the record?
Nothing from the people, Your Honor.
What was that date again? Yeah.
July 7th at 8. Wait, yeah, at 8. Okay. Where's it? Yeah. Oh, okay, got it. Or do you want it to? No, I didn't. I thought the felony was both of them. I didn't think the felony was both. I didn't think the misdemeanor was both. Okay, and the peer review is set for the other side. Got it. Okay.
Thank you very much.
Thank Yes, please.
Okay.
You can go have his tether removed. Christie is downstairs.
Yes.
This is the state of Michigan versus Aswana Thurman 26-00592. Appearance, please.
Thank you, Your Honor. May it please the court, Assistant Prosecuting Attorney Dan Smith, here on behalf of the people.
Assistant Public Defender Justice Strauss on behalf of Ms. Anjana Thurman, who is standing to my right.
Okay, today is the date scheduled for a crime violation and a assault and battery final pretrial. Do we have necessary witness here for the charge?
Your Honor, we do not. We have subpoenaed the complaining witness. We've made multiple attempts to reach out to the complaining witness. They have not had good contact with our office. So at this time, we would move to dismiss.
Oh, the alleged victim, her mom.
Oh,
Mhm.
it's her sister.
Her sister?
Yes.
And what is it? Okay, got it. The bond violation involves the mom. That's what the issue is. Someone was subpoenaed for the bond violation.
Ms. Thurman and Officer. Yes.
But no one's here.
Mom and Officer Morrow, but no one's here.
Are you continuing your mental health treatment? Motion to dismiss is granted. As well as the bond violation at this time. The people do have the right to reissue this against you. Do you understand that? The people have the right to reissue this charge against you. Do you understand that?
Yes, Your Honor.
Okay. Do you have any questions?
Is the bond dropped as well?
The violation is dropped as well.
The
The bond is over because
Okay.
the case is dismissed.
Okay, thank you.
We'll get you a copy of dismissal in just a moment. State of Michigan versus Christopher Askew, 26-00803. Yes.
Thank you, Your Honor. May it please the court, Assistant Prosecuting Attorney Dan Smith, here on behalf of the people. Assistant Public Defender Joseph Carney on behalf of Mr. Askew. Attempted to leave a message last week, as well as yesterday. Just tried reaching out to Mr. Askew this morning as well. So far, no response.
Show bench warrant for forfeiture. Bates is in custody, or they gonna put him, he's downstairs?
Yes.
Or she's downstairs? Okay. State of Michigan versus Louis Moshi, 26-01295. Yes, please.
Thank you, Your Honor. May it please the court, Assistant Prosecuting Attorney Dan Smith, appearing on behalf of the people.
Morning, Your Honor, Michael Puckett, student attorney practicing under MCR 8.120, under supervision of Justice Strong.
Motion to practice is granted. You are here today, Mr. Moshi, for domestic violence.
Yes, I have.
Okay, this is a pretrial. Was there an offer at this time?
There is no, been no offer extended at this time, Your Honor. We haven't. So we would ask that this matter be set for final pretrial, give us an opportunity to work with the defense counsel to see if we can resolve this matter.
Your Honor, that we would also ask for this matter to be set for final pretrial.
Final pretrial July 14th at 8 a.m.
Jury trial August 18th at 8 a.m. Final pretrial July 14th, 8 a.m. in person at the court. Jury trial is going to be scheduled for August 18th, 8 a.m. also in person at the court. We'll get you a notice to appear. Do you have any questions at this time, sir?
No, I don't.
Any additional?
Nothing from the people, Your Honor.
Nothing further.
Continue. State of Michigan versus Donald Ward, 24-03101. That's for the record.
Thank you, Your Honor. May it please the court, Assistant Prosecuting Attorney Dan Smith, here on behalf of the people.
Good morning, Your Honor, Michael Puckett, student attorney, requesting permission practice under MCR 8.120, under supervision of.
Our board present.
Your Honor, we are not sure if he is here yet.
I'm sure I've been sworn upon. Christie.
Christie.
You're fine here? For the record again, in the matter of the state of Michigan versus Amadou Mbao. Here.
Thank you, Your Honor. May it please the court, Assistant Prosecuting Attorney Dan Smith here on behalf of the people.
Good morning, Your Honor. Jack Rucker appearing again on behalf of Mr. Amadou Mbao, who is standing to my right.
Okay, this matter was scheduled for a second pretrial. No, a final pretrial. This was a final pretrial scheduled, the matter scheduled for jury trial on the 14th. We had a witness here.
No, Your Honor, we have attempted to reach out to a Ashley Park. We've sent her a subpoena. We have attempted to contact her via phone and send a detective out to see if we can make contact with her. At this time, we don't have the contact. We cannot move forward, so the people are moving to dismiss the case.
A motion is granted without prejudice. That means that the people can reissue this charge against you. Do you understand that?
I'm sorry, Your Honor, he's a little hard of hearing if the court wouldn't.
The motion by the prosecution for this case to be dismissed is going to be granted. However, they do have the right to reissue this charge against you. Do you understand that?
Okay, he's having a hard time, Your Honor. I will explain it to him in the hallway at a closer volume.
Well, you
but-
can explain to him on the record.
Very good. So, Mr. Mbao, what the judge is saying is that the case against you is being dismissed. So we will not have the trial on the 14th. However, it is being dismissed without prejudice, which means that they can bring the case back if they were to get in touch with it. You understand that? Court satisfied?
Do you have any questions?
Any questions? No.
Okay, we'll get you dismissal in just a moment.
Thank you very much, Your Honor.
No problem. Is Matthew Macon here?
No, Your Honor, I've not seen him this morning.
Yes, sir. Christie, Matthew Christie. Judge, for today's schedules have been tempting, but she's technically disposed for the disposition for the forensic. Wait, what happened? So the-
But I'll reach back out to her, talk to her before that date.
Scheduled her before then, but she's waiting for
Isaiah
forensic.
House.
Yeah.
Yeah.
I think he failed to appear, so. Whenever they pick him up.
Got it. Who represents Tammy Bates? She's still waiting for a forensic. We're gonna reset the bond violation until we get, after we get a report. She's not, she will be remanded until then. I think it's for July 14th. That's in just for review. July 14th, yeah.
So I think.
So your honor, you won't consider a bond for her today?
Isn't she being held in Eaton County anyways?
I do think she has a bond in Eaton County.
Yeah, no, she's got bond violations, 2 of them in here. Officer witnessed her himself in the bond violation. No.
I mean, my whole docket.
Everybody's disgusted. Everybody in jail for this one. Okay, let's see here. This is Mr. Matthew Christie.
Yeah.
Okay, 25-02579 appearance, please.
Thank you, Your Honor. May it please the court, Assistant Prosecutor Attorney Dan Smith, here on behalf of the people.
Assistant Public Defender Justice Straub on behalf of Mr. Christie, who is standing to my right.
Okay, this is set for a contempt hearing, and then final pretrial. We have witnesses here for the final pretrial.
I think you waived the appearance, Your Honor.
That's what I'm trying to look at is.
Yes.
Yeah, okay. I do see a note complaining witness to appear. How we proceed?
I defer to the defense counsel.
Your Honor, at this time, Mr. Christie would like to take the offer, which is trespass with restitution. The restitution amount is $1,150.
$1,150. $15.
Yes, Your Honor.
Okay, we need a restitution sheet. We need advice of rights. And what is he intending to do with the bond violation?
It's my understanding, Your Honor, that he will not be contesting the violation. $15. Your Honor, may I approach? Yes.
Mr. Satan. Okay, Mr. Christie, you want to plead guilty to trespass?
Yes.
Raise your right hand. You solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under the penalty of perjury?
Yes.
Okay, just put your hand there. Have an advice and rights and plea information sheet, that's your signature?
Yes.
You went over these rights with your attorney, correct?
Yes.
You understand that you have the right to the presumption that you're innocent, so you're innocent until proven guilty. You have the right to take this matter to trial and have the prosecution prove your guilt by proving each element of the charge beyond a reasonable doubt. You understand that?
Yes.
You have the right to remain silent at any trial. They can't use the silence against you, or you can waive silence and testify if you like. You have the right under the confrontation clause to see, hear, or question any witness called to testify against you. The right to subpoena witnesses that will testify on your own behalf. Or you can waive your silence and take the stand at your own trial. Do you understand that?
Yes.
And you wish to give up all of those rights?
Yes.
Anyone threatening you to do that?
No.
Any promises extended to you to get you to plead guilty?
No.
Are you on probation or on parole?
No.
You understand that by pleading guilty could result in a conviction that you may need to report to an employer?
Yes.
And are you wanting to plead guilty because you believe you're guilty of trespassing?
Yes, I am.
As to the amended charge of trespassing, how do you plead?
Plead guilty.
Okay, you're not objecting to the restitution amount of $1,115, correct?
No.
Actually,
Mr. Christie, on or about August 22nd, 2025, are you at the property of 1914 East Michigan Avenue?
Yes.
And at that location, were you asked to leave, sir?
Yes.
And did you fail to do that?
Yes.
That's fine.
how did we get to restitution of $1,115?
At that location, did you destroy any property?
That's from where?
However, we have had multiple final pretrials scheduled.
Yeah.
Is that correct?
Yeah.
Mr. Zaney appeared for those, the owner of that property, he appeared for those. You don't have any reason to contest that, do you?
No.
A big part of that, Your Honor, is Mr. Zaney's billable rate.
Oh, is that what the restitution is? It's
Yes.
not damage to property?
$125 of it is actual damage to the property, and I think that had to do with the screen. The rest of it is his
Like a
billable
screen
rate.
door?
Like a screen for a window, I believe.
Okay. And then the other is restitution for,
His billable rate.
I'm not following. You mean
So
restitution?
he had to appear to court multiple times.
Oh, got it. Okay, I was trying to understand, was he a client or, okay, got it. Okay,
It was missed wages, Your Honor.
okay, got it, okay. Should have set this for yesterday. This here. Okay, let's see, and as to the violation, the allegation is that he allegedly committed a retail fraud. It's February 22nd, 2026. You said he's not contesting that.
That is correct, Your Honor.
That's correct, sir?
Yeah.
Okay. And you at the Walmart located at 3225 Center Boulevard, Lansing, Michigan on February, on or about February 22nd, 2026?
Yeah.
And What happened that caused there to be police interaction?
I was with someone who was trying to shop with an air mattress, and so I was proceeded to be with them, so they took me into asset recovery, but they released me without charges.
It's interesting. It says shoplifting event occurred involving one person. Mentions nothing about another person. You was with someone else?
Yeah, I was with my friend.
It says at approximately 17:53, they witnessed an unknown female subject hand you listed item in sporting goods section. You then immediately concealed them under your jacket. Is that accurate?
Yeah,
So you're not being forthcoming when you said someone else was trying to steal.
they were, it was both of us.
It was you. We're not talking about someone else. You concealed something under your jacket, correct?
Yes,
Okay, so you were trying to steal. Correct?
yeah.
And you have a factual basis.
But people are satisfied.
Okay. The court is satisfied with the factual basis. I'll accept your plea if I your plea to be freely, voluntarily, and intelligently made. As it relates to the underlying charge, she's maxed out on these 30 days. Contempt is punishable by 93 days maximum. You can address the court.
Your Honor, until today, Mr. Christie had been forthcoming about what happened at these two locations, both relative to the malicious destruction that has been offered as a trespass today, as well as the retail fraud. He has also, I believe, spent some time now in custody. I would simply ask this court to give him credit where it can.
He spent time in custody because he refused to come to court. Not because he was sentenced on this. Like, do you know how long he's missed, how many times he's missed court on this? Do you have a job, sir?
Yeah,
Where?
I work commercial painting.
For who?
Jimmy,
Who's Jimmy?
my mom has got me an employer.
What's Jimmy's name?
My mom is in court, can I ask her?
No, if you work for him, you tell me his name.
I know his
How old are
name's
you?
Jimmy,
How old are you?
21.
You tell me who you're employed by.
Jimmy.
If otherwise, I don't believe you're employed.
I don't know his last name, I know his name is Jimmy.
How long have you been working for him?
I Start when I get released,
So you have not started, you never worked for him, correct?
right?
Okay, so how much you gonna make an hour?
I think he's like 16 an hour.
You think? Did you talk to Jimmy?
Talk to my mom, who Mike works with Jimmy as well. And Mike's
Who's Mike?
my mom's boyfriend.
Wonderful. What address are you gonna live at?
704 South Acre.
Assuming you're the mother.
Yes,
Yes, you are very antsy in the backseat.
I'm sorry. I have it set up, so we're staying with the American's Best.
Ma'am, I can't understand what you're saying, I'm gonna be
We're
honest.
staying at the American's Best, and it's set up so that, since we have another kid that's traveling with us, he's a traveling type. And we're gonna be here for the next 5 months, and so it's, the kid that's working with him, I have set it up with his boss that he's going to get into another room, so he's gonna have 2 beds. He's going to be rooming with him, and then they're going to take him in and start training him, and as soon as he gets released, I have a job and a place for him to be set up. So we can stay
Okay,
with
so he's not
American's
staying at 704.
That's where I was staying prior.
Yes, that's where he was before, but he.
My question was not where were you staying?
I don't know the address of America Vet.
Okay, but I asked you, where will you be staying? So you're supposed to tell me the answer to my question.
Okay, I'm staying in America Vet.
Okay, and so, and how long do you think you'll be staying there?
5 months.
5 months?
Yeah,
And you set it up, what's your name?
my name is.
Nicole?
Yes.
Okay, and you're his mother? Your last name is Christie?
Brown.
I'm sorry?
Brown. His name is
Brown.
Chris.
Okay, and so you made arrangements for him to work with someone named Mike or Jimmy?
Mike is my boyfriend. Jimmy Carroll is his boss.
Okay, and Jimmy owns a company?
More or less. They travel and
They travel where?
we were in Kentucky and, for a while, before that, Georgia. They come up north in 5 months, well, around September, we'll go up to Grayling. And then once the snow hits, we'll go back down south. And it's like.
Okay, got it. And so you're taking your son with you?
Yes.
Okay. How are you gonna pay your restitution?
I'm gonna pay it with coming out of my paychecks.
We need a payment plan. When are you gonna make your first payment?
And,
We're getting paid daily, and a portion of that will go to restitution, whether I have
So I can
to
make
boss do it or.
I can make a payment Thursday.
Of how much?
$100.
You're gonna be able to pay $100 Thursday of this week?
Yeah.
And then you're gonna pay how much monthly?
$500.
Are you positive? Your mom is not positive.
How much are we make? 300. 300 a month.
Pay $300 a month?
Yes.
Okay. The problem is if you say that and then you don't, it goes to a show cause and then warrant. If you say, I'll pay $100 a month, or I'll pay $50 a month. So I'm trying to understand, are you really going to pay $300 a month, or are you giving me lip service because you think that's what I want to hear? I don't. I want to hear how much can you reasonably pay? Because you have to put a roof over your head. You don't even know how much work you're going to have yet.
You can start with 100 a month.
If for whatever reason you require an extension or an adjustment to your payment plan, it is your responsibility to contact the court. I'm saying that so your mom can hear it, so she can remind you, because you have a issue with remembering court dates and responsibilities. You've missed court on this file 1, 2, 3, 4, 5 times. And it's always you wasn't aware or you can't remember. You're gonna have to remember your payment plan, because you could get landed back in jail because you didn't make a payment. And that's unreasonable. Remember your payment plan. If you need an adjustment, you call or contact the court and request an adjustment, okay?
Okay.
Credit time served. Any additional matters for the record?
Nothing wrong with you, Your Honor.
Nothing with that. Thank you.
You're all set.
Thank you.
Okay, let's see. Who shall you bring up for Miss Estrada? Who would you like next, ma'am?
We have a complainant witness.
Oh, for
Wyman?
what? For Wyman? Let's bring Wyman up. Actually, because I skipped Bates. We don't need Bates.
Okay.
This is the state of Michigan versus John Lee Wyman, 2660128 appearance, please.
Thank you, Your Honor. May it please the court, Assistant Prosecuting Attorney Dan Smith, appearing on behalf.
Assistant Public Defender Justice Straub on behalf of Mr. Wyman, who is standing to my right.
Mr. Wyman, this is an assault and battery pretrial today, and then also a bond violation, alleging that he had third-party contact with the protected partner. How are we proceeding today?
Your Honor, we will be contesting the violation.
Was there an offer?
There's no offer, Your Honor. People are prepared to move forward with the PA 53 violation.
Today?
Yes.
So you want a final pretrial on the other matter, or what do you want? The trial?
We can set for trial, Your Honor.
You call your witness.
The people call Stephen Collins.
I am gonna bring things up after this.
Let me tell them.
You raise your right hand. Do you solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under penalty of perjury?
Yes, I do.
You can have a seat, sir. State your first and your last name and then spell both.
Stephen Conklin, STEPHENCONKLIN.
You can proceed now.
Thank you, Your Honor. Mr. Conklin, I'm going to ask you a couple questions about an incident that brings you into court today. So give me a second. Start off by asking you some questions about this matter that took place on May 15th of 2026.
Okay.
Are you familiar with that date?
Yes, I am.
Okay. Is there's and there was a underlining issue that brought you to court before that particular date. Do you remember that incident? The assaults?
Yes.
Okay. There's someone here that you filed assault claims on prior to this May 15th incident.
Yes.
Can you point that individual out and describe an article?
John.
Your Honor, may the record reflect that the witness has identified the defendant.
Any objection? So noted.
So there was a previous assault claim that you filed against the person, right?
Yes, sir.
You remember what date that was?
3 days before the people showed up to the house.
Okay, so prior to the people showing up, this particular incident, you filed an assault charge.
Yes.
And to your knowledge, strike that. So tell us on May 15th, were you at 1822 Rex Street in Lansing? And is that your address where you live?
At that moment, yes.
Okay. And can you describe how you came to live at that address?
After speaking with John, John offered me a trailer for rent that was in his backyard at the time. I was eventually moved into the 1 bedroom, and then it moved to 2.
2 bedrooms in the trailer?
No, in the house.
In the house, okay.
Yes.
And then on sometime before May 15th, John assaulted you, right?
Correct.
And then on May 15th, after you filed charges for assault, tell us what happened on May 15th.
I left to go to the store with my kids. I came back, tried going into the back door. Wouldn't work.
And you have to keep your voice up a little bit because the judge.
Tried going into the back door. It wouldn't work. Stepped out. There's like a little breezeway right there. Stepped off the back porch. John's truck pulled up. 2 gentlemen stepped out. 1 Hispanic, 1 white.
And you said John's truck pulled up. Was John in the truck when?
No.
Pulled up? Okay, cool. But you recognize that as John's truck?
Yes, sir.
Okay, all right. Tell us what happened when it pulled up.
There's 2 people started being belligerent, particularly demanding I leave, threatening to hit me in the head with a hammer. Wouldn't let me go into the house once they went in. Basically refusing me to get my stuff after begging with them to be able to go in and get my stuff. I therefore spoke with my family member, which heard everything going on. And then they called the cops.
And these 2, you said there was a Hispanic individual and you say what, Caucasian individual?
Yes, sir.
Did you recognize those people before? Had you seen them before?
I had seen one in passing, but dealing with different incidents, but no, I have not had relations or dealt with them.
How'd you know that the defendant sent those people to that address to confront you?
The 2 people informed me that John sent them over there in his truck, and that John had full intentions of coming back to that address when he got out of work.
In order to remove you or to kick you out?
No, I was supposed to be already gone,
okay.
according to these 2.
Okay, so to prevent you from getting back into the.
Yes, sir.
Okay. And this all took place in the city of Lansing, right?
Yes, sir.
Ingham County, state of Michigan?
Yes, sir.
All right, thank you. No further questions.
John to you.
John's just an associated friend.
Okay, how did you come to meet him?
Met him through social media.
Okay. And so tell us how you go from social media to moving into his home.
We talked, he was informing me of some poor things or some bad things that happened to his life. I was informing him of some bad things that happened in my life. Told him that I had my son, and he had offered me the trailer out back, and I did not move on that until 3.5 weeks after.
Okay.
Then in that 3.5 weeks, it had went from the trailer to a bedroom. And then he had another person living with him, which I was going to be his stepson. He went to jail, and then it moved to 2 bedrooms.
Okay, so when you moved in, you didn't move in directly into his home. You moved first into a trailer.
No.
Okay.
No. The trailer was offered.
Okay.
Within the 3.5 weeks of me waiting to move in there,
Mhm.
I had to fix my truck so I could work to be able to pay him. He had changed to the trailer to inside the house. When me and John were talking, I said, "Oh, I must have upgraded."
Okay. Oh, so he was kind to you. He offered you
Yes.
a better circumstance. Okay. And how much did he charge you for that?
400.
Okay. And did you ever pay that 400?
Yes, it is.
I'm gonna object to relevance.
What's the relevance?
I see.
No, there's an objection to relevance, so you don't have to respond until I instruct you whether or not you can give the answer or not.
Part of the defense's theory, Your Honor, is that Mr. Weinman was simply availing himself to the benefits of the law through an eviction process.
By sending 2 people over.
Whoa, 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 whoa. What lawful eviction allows this? I'm confused.
So, Your Honor, we are contesting actually that Mr. Wyman sent two people. We actually have a video of the proof of service. We also have another
Service
witness
of what?
of the 7-day writ, Your Honor.
Okay, so you believe that your position is that there was proof of service of an eviction,
Yes,
okay, and that there, and then what? What does that have to do with whether or not you pay the rent?
but there was a basis for the eviction as
Well, you
well.
don't, in the state of Michigan, you really don't need, you can do termination of tenancy because you just don't feel like having them there. So that, whether or not you pay the rent is irrelevant. So he doesn't have to answer that. But I'll let you ask whether or not he was served with a notice to vacate.
Okay. Well, let's jump right to that, okay? Were you ever served with a 7-day writ, Mr.
The
Costa?
same day
Okay.
that them two gentlemen came over,
Mhm.
one, the white Caucasian gentleman,
So
was
I
the
would've-
one that came the second day morning
I would
and
object.
served me a 7-day notice.
It helps when you stand up. It makes him feel like you got something to say.
I would object to this entire line of questioning for relevance. We're here because the defendant committed PA 53 violation. And I don't think an eviction has anything at all to do with PA 53 violation, or him sending two people over to the house to contact this witness.
Objections overruled. Because if, and I don't know what she's laying foundation for now, if she's just trying to lay foundation to establish that someone was sent there to serve an eviction paperwork, that is within the realms of, he's allowed to serve an eviction on his property, even though this is pending violation for him, or pending violation from having no contact directly. Court order will allow him to send someone to serve that paperwork. However, this sounds like it was more than just service.
Yes.
Okay, so you said earlier in the day, could you, 10:30?
10:30 in the morning, the Caucasian gentleman showed up at the door, banging on the door. I opened the door. He served me a 7-day notice. A couple hours after that, he come back with the other gentleman and then wanting to force us out of the house. I didn't know that the Caucasian gentleman was the one that sent it until he informed me he was the one that served it.
Okay, so someone who showed up later in the day,
The same person.
you weren't aware that.
Are
he
you
was
not
the
following
same-
me? Okay, let me say this again for you. A white gentleman showed up at the door, 10:30 in the morning, served me a 7-day eviction. That same white gentleman appeared later in the day with an Hispanic gentleman to have me removed out of the house by their way.
Okay, I appreciate the clarification. You just said that you didn't know that one of the gentlemen that came later in the day was the same gentleman. Who
Now you're
served
playing
you.
on my words because no, I didn't know. I said he made me aware that he was the one that served me when he came back the second time.
Did you or did you not know it was the same person when he came back the second time?
I didn't recognize Noah's in the morning.
Okay, well, she's not playing on your words. That's exactly what she just asked you.
No, I didn't recognize him at first. Then he informed me he was the one.
Okay, so if I were to show you an image of that person, would you be able to identify them as the person who appeared at your home
Yes, I
earlier?
will.
Okay. And you said that was at 10:30,
Approximately correct.
Your Honor, permission to approach the witness?
I haven't had an opportunity.
I'm sorry. It's still shut here. Okay, do you recognize that house?
Yes, I do recognize that house. I cannot recognize that gentleman. I'm facing, this
Can
is the
you,
picture
excuse
behind.
me,
Yes,
Mr.
that
Conklin?
is
But
1822.
sir, you can only answer the questions
Yes,
that are
that is
asked.
1822 Rex Street.
I appreciate your testimony, sir.
Mhm.
I'm going to ask you at this point to answer my questions with yes and no responses,
Yep.
okay? So this is the home that you were living in at the time.
Yep.
Okay. Does this appear to be the person that you saw that day?
I cannot answer that question.
You cannot recall?
I cannot answer that question. That picture is taken 20 yards from the house and it's on the backside of it. I can't answer that question.
Well, let's play the video a little further. Let's see if maybe you can get something that helps you become more familiar. Bear with me, it's just a minute and 44 seconds. Looks like someone has opened the door. So you do recognize that name?
No, I did not say it.
You said that would be you, sir.
No, I did not. I said answering the door would be me. I cannot recognize that gentleman from the backside. I don't know. As far as I know, that picture
Sir,
could
there's
be.
no question.
Okay, so when the people showed up at, you said 10:30 in the morning, were they in possession of any weapons?
No.
Did they interact with you any more than simply handing you a piece of paper?
No, they did not.
Okay,
They were quite respectful.
okay. You say showed up later in the day. Did you ever get a chance to get their names? No. Okay.
No, I did not.
Okay. Did you ever actually see them in possession of any weapons?
No.
Okay. However, you mentioned that they had threatened you earlier.
Correct.
Okay, but they never had any weapons.
Objection, I don't know. I will ask. Just because they don't have a weapon does not mean they can threaten.
Well, by his very testimony, he said they threatened him with a hammer.
Oh,
no.
He said, when I'm dealing with an objection, you can't respond, sir. It requires me to address the objection and then tell you if you're lawfully allowed to answer the question or not, okay? There's nothing to do with you, it has to do with the question, okay?
Correct.
Okay. The objection's overruled. You can answer the question.
Never saw anyone in possession of a hammer or a gun or any weapons.
I never did see anybody in possession of a weapon.
And you did not see my client that day, you mentioned that as well.
Correct.
Okay, then how are you 100% sure, this time you can answer something other than answer. How are you 100% sure that Mr. Wyman is who sent them?
The two individuals informed me by verbal communication that John sent them over there to have me removed out of the house by them, let it be them hitting me in the head with a hammer or by other body in front of my children.
Okay.
That's how I know.
So it could very well be that that was not true. You never heard from Mr. Wyman yourself that he had sent people over to your home?
No.
Thank you. No further
Can you
questions.
redirect? Thank you. So you may be excused from the stand. Thank you.
Can I go back up?
Or you can stay here. It's up to you.
Oh, no.
You have any other witnesses?
No, the people were.
Argument. Are
Oh.
you are you calling witnesses?
I do have more witnesses. Your
You do
Honor.
have a witness?
I do.
Oh, okay, good.
Defense call Michelle Horton to the stand, please.
You raise your right hand. You solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury.
Yes.
You can have a seat. If you can state your first and last name and spell both.
Michelle Horton, MICHELE, HORTON.
You can proceed. Thank you.
Just for context, Ms. Horton, how do you know, or who are you to Mr. White?
I've been best friends with John Wyman for over 20 years.
Okay. And how are you involved in this situation?
Because John ended up needed it when he got out of jail the first time. He needed a place to go because he couldn't go back to his house.
Okay, And on May 15th, how would you have been at all related or involved in anything that happened at that Rec Street address?
The only thing that I know of is that I rode over with Melzer to give the 7-day notice or whatever, and I videoed it.
Okay.
That's the only part I have of it.
So how long would you say, well, let's start with, what time do you think you would have arrived? To the best of your memory.
I'd say it was, but I would say it was about 11, because John had to be to work that day.
Okay. So when you arrived, how long would you say you were there?
Probably maybe 10 minutes, because it took us that long to get him to answer the door.
Okay. And how many times that day did you go there?
Pardon?
How many times that day did you go? to
I
that
only
address?
went once.
Okay. And were you aware of any instruction from John to go back to that address later in the day?
No, I was not.
Who was Mr. Melzer? You just mentioned a Mr. Melzer. Who is that?
Clint Melzer.
Who is he?
He is a friend of mine and got to be a friend of John's for a minute. And when John got out of jail the first time, and John wanted to go get the 7-day notice, we rode down there with him to get it. I didn't go in with him. Clint did. And then the last I knew, he was supposed to be door dashing.
Okay. So Mr. Melzer is the person that went with you to serve the notice. What role did he play in that service?
He went to the door and handed it to him.
Okay, do you see Mr. Melzer here today?
No, I don't.
Okay. Your response it seemed to have some humor to it. Why
Well,
is that?
because Mr. Melzer is in quite a bit of trouble.
Why is that?
He stole my laptop computer. Him and his girlfriend, Alicia Matea, stole my Norco scripts from Kroger's. And they were caught, she was caught on camera. I identified her. So she's gonna go up on charges for that.
What's the relevance?
Yeah, objection.
What is the relevance to this case? Is a bond violation?
Well, Mr. Melzer, Your Honor, is now accused of stealing Mr. Wyman's truck. He was previously given the ability to drive that truck, but for very specific purposes, he has not complied with the scope of that
What's
authority.
that got to do with this?
Because we are alleging that Mr. Melzer went back to that property, if he did that on his own accord.
You want me to believe that Mr. Melzer cared so much about this person's property that he took his truck to his house to do a vigilante eviction because he just had nothing else to do?
No, Your Honor, I am saying that Mr. Melzer may not be the most
Mr. Melzer's not here. Mr. Melzer's not on the stand. We are not assessing his credibility. It's her credibility at stake right now because she's testifying.
He was subpoenaed to be here today, Your Honor.
Why are you questioning her about something that has nothing to do with this? It's not relevant. Move on.
Okay. Where was Mr. Wyman's truck after this incident? Who was in possession of that truck?
Clint Melzer.
Okay. And where was that parked?
It was parked at my house at 306 Brady. And he was told not to drive it because John.
Objection,
Hearsay.
objection, yes.
No further questions,
Sustained.
Your Honor.
Miss, I'm sorry, what did you say your name was?
Michelle Horton.
Horton, Miss Horton, were you at this property house where you served the eviction, you were there earlier in the day, right?
Yes.
You weren't there later in the day
No,
when this incident was alleged to have happened,
no.
right? Okay, no further.
Maybe excuse me, I'm thinking. Any other witnesses? Any other defense witnesses?
Yes, Your Honor, Mr. Wyman.
Raise your right. You solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury. You can examine him from there.
Okay. Mr. Wyman, did you send someone to the Rec Street address for any purpose on May 15th?
To be served. With
For
the
what?
7-day rec.
Okay. For any other purpose?
No,
Did you instruct anyone to threaten Mr. Conklin?
no,
Did you ask anyone to go to that address more than once?
no,
And you didn't go there yourself either, did you?
no.
No further questions? Cross-examination.
You are Mr. Wyman. Mr. Wyman, I'm Dan Smith, I'm the prosecutor. I'm gonna ask you a couple questions about your testimony today. If you don't understand the question that I give you, you can ask me to rephrase. If you answer the question, I'm gonna assume that you've understood the question, you're answering that question wrong. Are we comfortable with that?
Yes,
You agree on that?
yes.
So, Mr. Wyman, it sounds to me as if this matter arises over a property dispute, right?
Yes,
And you say that Mr. Conklin was supposed to pay your rent.
that is correct.
He didn't pay your rent.
That is correct.
And you wanted him to leave the property.
That is correct.
And he didn't leave the property.
That is correct.
So that made you upset.
I had to serve him.
My question is simple.
Yeah.
It's just yes or no.
No,
You didn't leave the property. You weren't upset that he didn't leave your property after not paying?
no,
Okay, so you just let him just stay in there, right?
Yeah.
So you didn't issue a writ.
yes, it was issued.
My question to you is, were you upset that he did not leave your property after not paying rent? Yes or no?
Objection, Your Honor, asked and answered.
Okay, so,
Are you withdrawing your question?
no.
Oh, okay. Objections overruled. You can answer.
So again, my question to you was, you said you weren't upset with him leaving, but you issued him so you didn't think that he should continue to stay, right?
Correct.
So you issued a writ.
Correct.
And you had your friend go over and serve that writ.
Right.
In your truck.
Correct.
With some other.
Not serve it. He didn't serve it in my truck.
You had your friend go over and serve a writ, right?
With Miss Horton.
With Miss Horton.
In her vehicle.
You tape that, right? And she taped that.
Mm-hmm.
Right? And
Is that a yes?
Yes.
this friend that you had go serve the writ earlier today, does he have access to your keys to your truck at all times?
No.
So on this particular occasion, he got access to your truck
Yes.
without your knowledge.
Yes.
Okay. Where are the truck keys located?
Miss Horton.
Okay. And Miss Horton's your friend, right?
Yes.
Okay. And he got the keys to your truck.
Yes.
And he got another one of your friends.
No,
Oh, okay.
I don't know.
So you got the keys to your truck after serving the writ. The guy who gave him the writ earlier in the day.
Yeah.
He got access to the keys to your truck.
Yes,
You went back to your property.
I did not know.
You heard his testimony.
Yeah.
So he's testified that they came back to the property. Did you hear his testimony? Were you here sitting in court? You heard his testimony, right?
Yep.
His testimony was that your friend, how long were you friends with this guy?
A day.
I'm talking about the person that you sent over to issue the writ who came back in the day. Were you only friends with him for one day?
Yes.
You let a person who were friends with one day get the keys to your truck. Is that your testimony?
Yes.
Okay. And you let this friend serve a writ for you on your behalf. Somebody you didn't know.
Correct.
Okay. And you authorized Miss, what was her name? You authorized her for that guy to get the keys to your truck.
Yes.
Okay. A person that you didn't know. You said, hey, take the keys to my truck. No problem. Go issue this writ for me. Is that your testimony?
Objection, Your Honor. I'm not sure what the relevance here is to the truck.
It goes to his credibility.
This definitely goes to credibility.
For who, Mr. Melzer or for Mr. Wyman?
Mr. Wyman.
So do you need me to repeat the question?
Yes.
My question is, you let a person who you had no clue who this guy was, right?
Correct.
You authorized him to get the keys from Miss Melsner,
Miss Horton.
Miss Horton. You authorized him to use your vehicle that day.
I was dropped off at work.
Do you remember the question?
Yes.
The question was, you authorized that guy who you didn't know to get the keys to your truck to go issue a writ, right?
No. No, his testimony was that the truck wasn't used to issue the writ. They went in Miss Horton.
Miss Horton.
Miss Horton's vehicle to issue truck.
Okay.
Then he later gave this person that she testified they had became friends, but he said he is now testified that they just met each other. He gave the car to his truck to him that day for whatever purpose.
So, some time later, this person that you didn't know got the key. So he didn't have keys to your truck earlier, but sometime later in the day, he got the keys to your truck, and you heard him testify that individual went back over to the house and threatened.
Yeah.
Right. And this person that you did not know, and who did not know the guy who testified, went, or it's your testimony that individual went back to the house to threaten this person, and it wasn't at your request.
That is correct. Okay. It was not at my request.
And do you believe that testimony is reasonable? Do you believe it's reasonable for a guy who didn't know him, didn't know the complaining witness, and who doesn't know you, would go over to a house and threaten someone because he didn't pay you rent? Is that reasonable?
No.
Oh, I agree. It's not reasonable. No further questions.
Can you redirect?
John, was Flint a mutual friend between you and somebody else?
Yeah.
So it wasn't like you had just met him the day before on the street, right?
Right.
Okay, so you kind of had a reason maybe to, I want to say trust, but to believe that maybe giving him.
Are you asking him a
I'm sorry.
direct question or a leading question?
I'm trying to ask a yes or no question.
This is your witness. You can't ask him a yes or no question. So it's, did you have a reason to trust him versus suggesting the answer?
So did you have a reason to trust Flint?
Yeah.
Okay. And You were dropped off at work, correct? That's before the service. They used your truck to use. Why? How did you get to it?
I drove my truck to work.
And then how did your truck go to?
Because
Your Honor, I didn't hear the question.
How did it get to?
How did your, after you went to work, how did your truck get to?
He.
I would say objection. Cause for speculation.
Your Honor.
How's his truck? I think he should know how his truck got there. I'm gonna rule that objection. You can answer the question.
Okay.
Is that the person's name?
The question is after John
Yes, not in the
drove.
report, Your Honor. Yes,
How-
his name's Clint.
Yeah.
Okay, who is Clint?
I don't know. That's what I'm at.
The person who served 7-day writ.
The person.
Okay, this is causing confusion because 7-day writ was not served in the truck, correct?
Correct.
No, Your Honor, I just want to clarify that Clint is the individual that Mr. Smith was just saying, questioning as to John's credibility as to why he would give him his keys.
I think it was another person. I thought.
No, it was Clint.
It was Clint. What's Clint's full name?
Clint Melzer.
Okay, let's use it. Let's be consistent with the name so we don't get confused because there are 2 males alleged to be involved. So so it's the same person you're talking about.
I guess. I mean, I didn't know who the person was. But...
Clint Melzer. Okay.
Clint Melzer.
So my objection is a call for speculation because it says he was dropped off at work, and I don't believe there was a foundation for him to say how the truck got well.
Did he give him? I thought he was allegedly giving his truck to the person.
Your Honor, if I may. So the prosecution is essentially saying that.
The objection's overruled. He can answer the question.
So after you drove to work, how did Clint get your truck?
After I was dropped off at work, he asked if he could use my truck to do DoorDash. That's the last I knew.
Okay. Did you ask him to go do the service along at any point?
That was earlier with Miss Horton.
Okay, so after, I just want to make sure the timelines are right. So after Clint Melzer had performed the service, you allowed him to go use the truck for him.
Yes.
No further questions, Your Honor.
I have just a couple follow-up questions. If everyone's referring to a writ, you had a lawful eviction that was in process during that time?
Yes, it was.
Okay, and a writ had been issued?
Yes, it was.
Okay, and so did you tell law enforcement that you were of the understanding that you could tell Mr. Melsner and the other person to go lock your property up to secure it?
Yes.
So why are you now acting like you didn't know that they were going over there?
Mr. Melsner went over by himself to lock my doors, which he did. Nobody was there.
How do you know that?
Mr. Melsner said that to me.
When did he go over there by himself to do that?
After I was dropped off at work.
You said somebody back over there.
I asked him to go and check to see if anybody was there. To lock my doors.
Argument.
I think it's clear, Your Honor, that at any rate, that the defendant could have used the police if he had a lawful writ, or if he was under the eviction process. There's a right way and a wrong way to do it. You don't send your friends, a person that you trusted with your truck, to use DoorDash, and now you're coming to court saying that this might have been a friend or wasn't a friend, or he did this on his own. I think it's clear. The defendant claimed that his own story wasn't reasonable. It's not reasonable to believe that the defendant did not send them back over there to do self-help and to lock this place up when he should have used the police. So based off of the testimony that you heard in the credibility of this witness testimony, I'm asked that you find him guilty of the PA.
Yes, Your Honor.
Actually, I might just do this one.
Thank you.
Your Honor, I don't think it is the service that is in question. I think that what the prosecution's theory is that later in the day, when these 2 men, who one of them is presumed to be Clint Melzer, we don't know because the police report does not accurately identify who exactly the 2 men were. That's kind of what we're inferring based off testimony from Mr. Congress. Now, Mr. Wyman has a fundamental right to pursue an eviction process. There is a genuine question as to whether Mr. Conklin was even legally allowed to be at Mr. Wyman's residence.
Not in this case.
So, well, after, we would say that after, I'll move on from that. As to Mr. Conklin's credibility, this is an individual, so Mr. Conklin, the complaining witness in this case. So from the police report, what we know, and from Mr. Conklin's testimony is that when the two men arrived to do whatever they did at the house, which we're saying that John did not ask them to go there. Now,
You just told me he sent them.
what we're saying, he did not send them there to threaten. So
He sent them there, which is a violation. That third-party contact was not allowed. He had already served them. He then sent somebody back over there at his direction. The testimony is that he said, that Mr. Conklin said, is that Mr. Wyman sent him over there to lock the property up and get him out of the property. That was the testimony that he gave.
Your Honor, if I can continue, what we would draw into question is Mr. Conklin's credibility as to what actually happened. So I just want to go through a little bit. So around 6:25 p.m., this was when Mr. Conklin and his kids returned. He asked, this is from the police report, he asked permission.
We can't testify from a police, you can't give argument from a police report to me. You cannot give me argument on a police report.
Okay, I'm sorry, Your Honor.
Yeah, that's not evidence.
I'm talking about.
You can only give argument on the evidence that was brought forth.
So from the testimony, Mr. Conklin is saying that these two men had threatened him with a hammer. He did not see a weapon. There was no weapon involved. There were no threatening, no threatening statements really.
There was a threatening statement. He said that they threatened to use a hammer. They said we will hit you with a hammer. He did say that they didn't see the hammer. He did see a hammer, but threatening statements were made that based on his testimony. So that argument is not accurate as it reflects the testimony that was brought out.
And that's Mr. Conklin's testimony. We would argue that Mr. Conklin had a financial motive to fabricate or exaggerate claims. There's a financial motive to have my client locked up so that he can stay in his house rent free. That is essentially what happened in this case. And Mr. Wyman, he was a vulnerable individual during this encounter, just lost his husband not long ago. I believe that the situation.
Who is this?
Mr. Wyman, my client. So I'm just saying, I believe that this was a situation of a vulnerable person being taken advantage of. And I just think that the complaining witness here has a motive to fabricate.
Okay. You don't believe though that your client also has the same motive because this is his property. He owns it, correct?
Yes. He rents.
He does not.
He was living there.
Yes.
He doesn't own the property?
He does not own the property.
Well, how is he doing an eviction?
It was a very imperfect process, Your Honor.
He doesn't own the property?
He does not.
How is he doing an eviction? How does he have a lawful right to serve a writ? You just argued that he had a lawful right. You told me that. You told me he had a lawful right in your argument. He doesn't own the property?
He has a lease.
No.
He has a possessory interest, Your Honor.
Yeah. How are you have a lawful right to issue a writ on somebody?
Your Honor, we don't believe the process that Mr. Wyman used. He was doing this honestly.
So it wasn't lawful. It was very vigilante.
Very imperfect.
It was very vigilante. I've heard enough. I've heard enough because I 100% believe that Mr. Wyman sent someone over there to lock this man out of the property. This has nothing to do with whether or not he was vulnerable. This had nothing to do with whether or not rents had been being paid or whether or not he had a lawful right to sublease. That really has nothing to do with that. This has to do with the fact that before me, he was arraigned. He was told not to go back to that property. He told me he was going to be staying with his father, gave me the address of 1508 Redwood. He wasn't staying with his father. He was staying with her. He then decided he was going to execute a writ or issue a writ and have this man removed so that he can get back in the property. That's what this has to deal with. And after the writ was served, because she has already testified that she's gone and with someone else and recorded serving the writ without issue. If he had to let it stay there, he wouldn't be in this position. He then later sent someone back over there with his truck. He told me, that's why I asked the question I asked, because he evaded it when he was asked on direct. He evaded it when he was asked on cross. You're not going to evade it to me because I know what it was alleged that you told the police. And you allegedly admitted to the police that you sent the guy back over there. That's why I asked you that. Oh yeah, I did send him over there. Because I thought, yeah, that's not what you said when you were asked by the prosecution. You said you didn't know he was going back over there. He did know he was going back over there. And if you are engaged in a criminal action and there's a no contact order, and you then are moving forward with a lawful eviction, you must use a process server. Not some vigilante person you may or may not know, because 1 minute you say you don't know him, you just met him, next minute you do know him. The other person would say he's a mutual offense, that he's a criminal and he stole from. You definitely don't send them. And you definitely don't do a lockout. If you serve them with a writ, giving them 7 days, you can't now go lock the property the same day. So I'm sustaining the violation because he absolutely violated the conditions of the no contact order. Why is your hand raised? You should talk to your attorney. You can address the court one sentencing on the violation.
Your Honor, admittedly, Mr. Lyman has not availed himself to the courts in the way that we would expect him to, or by the rules of the court. It has been shown multiple times today that he is a very trusting person, and he doesn't necessarily have all of the faculties to go through this process in a legal and lawful way. I do believe that he is apologetic about that. We would ask this court to consider time served today. I do think he's been in custody now since the 15th of May. Thank you.
All right, want to make a statement.
Your Honor, I served him the writ and I sent Mr. Meisner over to lock my doors because he was not there, but I did not.
How'd you know he wasn't there?
Because Mr. Meisner came back and informed me that the house was locked.
If it was locked, why are you sending someone to lock the property?
He went over to lock the doors and then he came back.
How did you know to send someone over there to lock the doors?
How did I know?
Yeah. If you don't live there, you don't have communication. How would you know if someone's in the property or not?
Because I told Mr. Meisner, if there's a vehicle there, which was Mr. Conklin's, to not enter. And the vehicle was not there, so he entered that property because
Unlawful contact.
Mr. Meisner.
Unlawful contact.
But I did not send them, was unaware that they went back.
Well, you sent them back. So you sent them to go lock the property.
One person, not.
Doesn't matter. You can't send anybody.
Right.
You couldn't send anybody. Do you understand that?
Yes, I do.
You're not allowed to send anybody.
Yes.
No third-party contact.
Yes, and I was unaware of that.
No, you were aware that there was no third-party contact. It says it in your release form.
I did not get a release form.
We went over your bond. I arranged you myself. I know what I said.
All I got was paperwork.
No contact, directly or indirectly, is what I said. And I signed the bond order. You didn't tell me you left the jail without a copy of a bond order. They don't do that down there.
All I got was a piece of paper that said I was due for pretrial. That was all I got.
There, and a PA 53 form was attached to it.
No.
They don't release you without a PA 53 form.
Okay.
You told the police that you thought it was okay to send somebody over there to lock the property. This was after the writ was served. I would have let you slide on sending someone to peacefully serve the writ. But sending somebody back over there to check to see if the property is vacant, and if there's a car there, leave. If there's not a car there, lock the door. You don't even know if he went to the store. You were doing a vigilante eviction, and you were trying to lock him out the property. And you can't make people believe anything other. I find that you did lack credibility when you tell me that story. I'll give you credit, time served. You've been sitting in jail for 30 days for this, or yeah, just about. So I'll give you credit, time served. I don't want to have to reiterate your bond conditions to you. Do not try to mince words with me. I arrange you myself. I say it like clockwork. You cannot have contact directly or indirectly with the protected party. At no time when I arraigned you, did you tell me, well, Judge, I have a pending court case with him because I filed for an eviction. You didn't mention that. Am I allowed to have someone serve him? You didn't do that. At which point we would have directed you on who specifically could serve him. You didn't do that. You didn't mention any of those things. You also told me, I asked you, where will you be staying? We'll stay with my father. You, per your bond conditions, have a requirement under the order to make sure I know where you're staying. And if you change it, you got to let me know in writing. Did you tell me you were going to be staying at her house?
I stayed at Miss.
Did you tell me, I'm telling her, she already testified you had been staying with her. Did you tell us that you were staying somewhere else?
No.
You probably ain't never stayed at your father's house since I let you out.
I was only out 2 days, ma'am.
I arraigned you on the 13th. When did this incident occur?
On the 15th.
On the 15th. You didn't stay, you said you were going to stay at your father's house. That's not where you went.
Right.
You went to go try to do a vigilante process so that you can get back in the property.
No.
Yes, you did. Go back and forth with me again.
No, that's okay.
That's smart. You're not allowed to have contact directly or indirectly with this protected party. That means you can't send anybody else to talk. You can't send anybody else to go check on him. You can't send anybody else to go stare at him. You can't send anybody to go lock any doors. At this point, he's testified that he's out of the property.
I understand.
And so you are allowed to return to the property if you're still a lawful renter or leaseholder on that property because he has testified he's not there anymore.
Correct.
But that still doesn't allow you to have any communication,
Correct.
directly or indirectly. If he's at Burger King, you go to Wendy's. If he's at Kroger, you go to Meijer. You understand that?
Yes, ma'am.
There should be no confusion at this point, correct?
Yes, Your Honor.
Is there any other potential court cases that you have pending with him?
No, Your Honor.
Okay, any other reason why you think you might want to try to send someone to check to see if his car is there?
No, Your Honor.
Okay, any additional matters for the record?
Nothing from the people, Your Honor.
Not from defense, Your Honor.
Okay, you should be released today. You're all set.
The jury trial,
Thank you, Your Honor.
Jury trial date,
August 25th at 8.
August 25th at 8 a.m. in person at the court. David, I'm gonna need a new bond for him because he's gonna return to the Rex address.
Oh, yeah.
Then when you look back, you can bring Bates up.
Thanks, okay.
Let's see. Mr. Amadeo is here.
Morning, Your Honor.
Okay, and you are representing Marie or Taylor Little?
That's correct, Judge.
Okay, this is the state of Michigan versus Taylor Little, 25-00247, appearance, please.
Thank you, Your Honor. May it please the court. Assistant Prosecuting Attorney Dana Smith here on behalf of the people.
Good morning, Your Honor. William Amadeo, P76194, on behalf of Tara Little. We both consent and appreciate being on Zoom. Taylor, please state your name for Judge Simmons and her staff to know it is you on Zoom.
Taylor Marie Little.
Thank you.
Okay, this matter was scheduled for assault and battery, and I know we reset this because you had recently been conflicted on the case. Let's see, was there an offer yet?
There's no offer. I believe me and defense counsel have had a few discussions, but we've made no offers. I asked this matter be set for final pretrial. Give us time to come to a resolution.
I have no issue with that, Judge. Just for the record, though, she has a felony prelim in your court in 2 days, which is not mine. So I was waiting to see what happened with that. I just found out about the other file, and obviously that would take priority over the misdemeanor. But I'm no issue kicking it out for a final pretrial if that's what the court and the people desire.
Final pretrial, July 14th at 8 a.m.
July 14th at 8 a.m. for final pretrial, in person at the court.
Jury trial, August 25th.
August 25th at 8 a.m. for jury trial.
Thank you, Judge.
No problem. Ms. Little, do you have any questions today?
No.
Any additional matters for the record, counsel?
Enough from the people.
Not from the defense, Your Honor. Thank you.
Thank you. Someone was in the
Thank you.
jail. I had to break out room. Let's bring him back.
I know. Lord says that you should have had enough.
Yes, it's just not important. Did the jail leave? Oh, maybe it's just a delay. I don't know. I don't see them anymore. I don't see. I just try to bring them back. Who's on the iPhone?
Pardon, reader?
Oh, there's the jail. Who's in the jail? Is that Davis? Jalen Davis? Everyone else is on the red. Okay, I don't. So that must be it. This Mr. Davis?
It is.
Okay, are we ready with
Yes.
Mr. Davis?
Your Honor, I would actually like to speak with him.
Okay, Mr. Davis, your attorney's gonna log in just a moment to meet with you. For the person on the iPhone, there's multiple. And someone's on a Motorola. What's your name, ma'am?
Jaquel Gibbs.
That's your 12 Gibbs.
I believe that's.
Well, why in the world is she in my screen then? Where is Jaquel Gibbs?
I'm right here.
Let me see Jaquel Gibbs, please.
Just one moment. How you get to the picture? You want to see your picture? How you see your
Oh, grandma double tap the screen and then.
I see you, I can see you, but you need to be in the screen, not your mother, grandmother, or whomever she is, okay?
Oh, okay, okay, yes, ma'am.
Who's on the Motorola?
Oh, my grandma.
No, I ain't on the motor.
No, I'm not.
Oh,
I'm talking
oh,
to someone else. I'm talking to someone else. Unmute your device to the person smoking with the Motorola.
It ain't not us.
It ain't none of us, you know that.
I mean, Jesus.
I'm on the iPhone.
I'm not talking to you, ma'am, but what is your name?
My name is Kelsey P.
Thank you. You're on here twice for some reason.
Because it wasn't.
I'm talking to the person on
It
the
wasn't letting me
Motorola.
pull up the video on my computer, so I had to get on my iPhone so I can pull up a video.
Okay,
So
I'm gonna remove the device then. Okay, very good.
Thank you.
No problem. Maybe if you put whatever you're smoking down, you can see that you need to unmute. And ma'am, who I believe you're holding a child or a child's laying on you, what's your name?
Marissa Collins.
Okay, Collins is here, Gibbs is here, and Petener is here. Let's see. And we have we have Gibbs. And then sir, on the Samsung, can you tell me your name? I'm gonna remove the person who doesn't know how to unmute themselves. Your volume is really low. I couldn't hear you. Sir?
I'm sorry. Jonathan
Yes, your name?
Johnson. Yes.
Jonathan Johnson. Very good. Okay. We're ready on.
We're ready to proceed on both Collins and Gibbs, Your Honor.
State of Michigan versus Marissa Collins, 26-01205 and 1206. Appearance, please.
So thank you, Your Honor. May it please the court, Assistant Prosecutor Smith here on behalf of the people. Assistant Public Defender Joseph Hardy on behalf of Ms. Collins, who's apparently assumed.
Okay, Ms. Collins has a dog license vaccination ×2. How are we proceeding?
At this point, Ms. Collins has informed me that she has a vaccination appointment set for a week of Thursday, so the 25th of June. At this time, we would just ask for more time for her to both get the vaccination and also get the license. Once the vaccination has been completed, we would ask for 3 or 4 weeks.
July 7th at 10:30. July 7th at 10:30. You have any questions for the court today, Ms. Collins?
No, Your Honor.
Any additional matters for the record?
Nothing from the people, Your Honor. No, Your Honor.
You're all set, ma'am.
Thank you. Have a great day.
Same to you. So you were ready on who else?
Gibbs.
State of Michigan versus Jaquel Gibbs at 25-01092. Appearance, please.
Thank you, Your Honor. May it please the court, Assistant Prosecutor Attorney Dan Smith here on behalf of the people. Assistant Public Defender Joseph Hardy on behalf of Mr. Gibbs, who's appearing via Zoom.
Mr. Gibbs has 2 counts of assault and battery. Was there an offer?
There's no offer at this time, Your Honor. I asked that this matter be set for final pretrial, and we give the parties an opportunity to develop a resolution. No objections.
Final pretrial July 14th at 8 a.m. Jury trial August 26th at 8 a.m. Mr. Gibbs, you need to appear in person for every single one of your future court dates. You should never appear via Zoom again. Do you understand that? Unmute yourself, please.
Yes,
You
I understand,
that?
Your Honor.
Okay, it's very disruptive. It's conversations going on in the background. Your grandmother or your mother is operating the device and not you. That's not the appropriate way to use Zoom court. And so you will appear in person for all. You will appear in person for all of your court dates. Your next court date is July 14th at 8 a.m. Your next court date after that will be August 25th at 8 a.m. in person. Do you understand that?
Yes, I do, Your Honor, and thank you very much.
No problem. Any additional matters for the record?
Nothing from the people, Your Honor. No, Your Honor.
You're all set. You're free to go, Mr. Gibbs.
I was the one that pressed unmute that time too, Your Honor.
It was not just one time, it was multiple times, actually. But you're all set for today.
Yes, ma'am.
Your Honor, can I speak to
I will.
She needs to speak to your attorney.
No, she has. Sure this point? Did she get sure this point? No.
For whom?
Emily Bedell.
I did not call the case. Is she here?
No. She is not. I did not see her in the gallery or the hallway, and our office currently does not have any contact information listed for her either.
Well, it should be short, you know. Okay, and are you representing anyone else or are they on this trial?
I have Maurice Quayles, similar situation as to Bedell. It's
No contact.
no contact information listed with us, and they're not seeing them in the hallway or the gallery. And finally showed that had found it out.
So everybody is. No worries. Let's see, this is Ms. Bates. I don't know if he gave me their file back, did he? The record in the matter of the, wait, who represents Ms. Bates?
Judge, Attorney Strong.
Oh, okay.
I think she's talking to.
She's talking to the person in
James Lamar
custody.
Davis.
Mhm. And then Mr. Reader, does he represent himself? Yeah. We should do that.
Martin Reader.
Yeah, it's probably a motion to set aside a conviction. You're on the record in the matter of the people of the state of Michigan versus Martin Reader. That this is in file number 20-01496. Council might have your appearance, please.
Thank you, Your Honor. May it please the court. Assistant Prosecutor Attorney Dan Smith, appearing on behalf of the people.
Okay, Mr. Reader is present via Zoom. Mr. Reader, you are without counsel for this purpose, correct?
That's correct.
Okay, this is the date scheduled for a motion to set aside a conviction. The court is in possession of your request. You're seeking to set aside MVOP less than 200 and assault and battery from date of conviction, July 23rd, 2020. The court does have a letter from the Office of the Attorney General. They have no objection to the setting aside of conviction if the court determines that it's consistent with the public welfare. Would the county prosecution be taking a position at this time?
We defer to the court, Your Honor.
Sir, please advise the court what you've been doing since 2020 when this conviction was sustained.
Well, all the conviction stuff was surrounding a divorce. Since the divorce, moved forward in my career, promoted a couple of times into supervisory positions, operating a small business, and then the divorce. My co-parent, we've developed a good co-parenting relationship, and things are going well there too. Aside from that, I've been just raising my children. I just got married in February, so now I have a stepson as well. And I built a house also.
So you've been busy
Very
and
busy.
productive. The court does have or have received letters of reference and support of you, one from Delta Township, and then one from a Luke McAllister, and then an Angela Reader, and then lastly, I believe, Anthony Warner. So all very positive letters of support from your community. I want to applaud you for regaining control over your situation. I don't think had any other convictions ever other than this situation. So you're a classic candidate to have this set aside. I find it to be consistent with the public welfare. I'll grant your request today.
Thank you.
Thank you. You're all set. Thank you.
Thank you.
No
Is there, since I'm without counsel, is there anything further that I need to do on my end?
There's nothing you need to do on your end. I signed the order. It'll be sent to the state police so that they can retract what needs to be retracted.
All right. Thank you very much.
You're welcome. Best wishes to you, sir.
Bye.
Okay, this is the matter of the state of Michigan versus Tammy Bates, 26-00375. Appearance, please.
Thank you, Your Honor. May it please the court, Assistant Prosecuting Attorney Dan Smith, appearing on behalf of the people.
Assistant Public Defender Jessica Straub on behalf of Ms. Tammy Bates, who is standing to my right.
Okay, Ms. Bates was scheduled today for a bond violation. And the court had already indicated to the your counsel, that we would hold the bond violation until after we've gotten a competency evaluation report, which I think is pending. I think they've done the evaluation and we're just waiting for them to send the report. However, and I wasn't going to address bond due to the pending violation until I learned that there was someone here in support of you. Is that your mother?
Yes, ma'am.
Okay. And so she's very concerned about your well-being, and that shows the court that there is someone that's at least going to look out for you, make sure you don't miss your court dates to the extent that they can. You wanted to address bond.
Yes, Your Honor. It is my understanding that Eaton County has issued a bond for Ms. Bates. So based on what you just said, the support of her mother, we would just ask this court today to consider releasing her as well on a bond. Even if the court thinks that it's appropriate to have a tether, we would absolutely be amenable to that as well. We leave it to the court's discretion.
I'll issue a PR bond with GPS tether. So you're going to reside with your mom, or where are you going to reside?
1338 Eureka.
Okay, that's the same address you've been residing at.
Yes, ma'am.
Has your telephone number changed?
Well, my phone has been off since I've been in jail, so I do not have that information, but my mother's number is a very good number to call.
What's your mom's?
517-243-0437. And I will make sure that I come to every court date.
We don't remember phone numbers anymore, you know that, but we always remember our moms, at least we should.
Always.
Have to.
She remembers.
It's been that way for years and years and years, so I think that's why too.
You should remember that. I was recently talking to someone and they were like, something happens, I don't remember anybody's phone numbers. You remember someone, your emergency contact.
Always remember my mom. She's my support.
Agreed. And you know how you can support her back?
How, ma'am?
By not making her have to come to court for you.
Absolutely. I'm going to put myself in outpatient rehab, and I'm also going to try to get into RISE for sober living.
That's good. RISE recovery, probably a really good place for you to be. Hopefully, your attorney can help you navigate getting connected to that program.
Thank you, ma'am.
Okay, so we will, I think this matter is scheduled for a review July 14th. That review only is going to go forward to the extent that we actually have received a report. If we receive a report before then, once you receive a report, I have to hold a hearing within 5 business days. So you'll be notified. So that's why we have to have valid contact.
Okay.
So that whenever we get the report for the forensic, it's going to be set immediately for a court hearing. Your attorney is going to try to make contact with you or your mom if your phone's not on to let you know. You do not need to appear in person for that. So if you have a video on your camera, you can appear virtually, okay? Just be in a quiet place that's appropriate for court, okay?
Yes, ma'am.
Otherwise, if you don't have the ability to appear via Zoom in a quiet place, just come in person, okay?
No, ma'am.
Okay, do you have any questions?
Oh, my mother would like you to send a mail to her house.
What's that address?
7930 South Lowell Road.
South
Lowell Road, St. John's, Michigan.
48879.
Spell your street name. Spell it, the street name.
Lowell.
Lowell, okay, very good.
South Lowell.
South Lowell, I have that. I just didn't know if she was saying low or Lowell, okay. Very good, so we will have mail sent there, and then we have your number, but Ms. Straub also has your mother's number if she needs to call you for that next hearing.
Yes, ma'am.
So that you can appear immediately for that, okay?
Yes, ma'am.
All your other bond conditions will continue, including the no contact order,
No
especially including that, okay?
Yes, ma'am.
No contact directly or indirectly. You can't be within 2,000 feet of where that location is. And because you're gonna have a tether, it's going to alert you
Yes,
and us if you are within that jurisdiction, okay?
Promise.
Okay, very good. She absolutely can come to your house. Absolutely. Is she going to stay at your house or you may just visit?
Visit. I have a curfew and everything with the tether, correct?
I have not given you a curfew at this time.
Okay. I can go to my mom's house.
You absolutely can go to your mom's house. Any additional?
Thank you.
You're welcome.
Thank
Any
you so
additional
much.
matters for the record?
Nothing from the people, Your Honor.
Thank you.
Thank you. You'll be released once they can get you the tether, okay?
Thank you, ma'am.
That's gonna be in Mason, okay?
What about Eaton County?
Oh, that's right. You're in Eaton County. You
Yes,
gotta,
ma'am.
they'll release you now. They were holding you because there was no bond here.
Okay.
But it sounds like she has a bond in Eaton County.
Yes, I do.
Okay, so
We're
once you,
prepared to pay it.
I don't know what that bond is. That's up for you all to take care of. You don't have to pay a bond for this one. You just gotta get a tether.
Okay, yes,
And
ma'am.
I'm sure, I believe you're eligible for the indigency status so that the payment will be covered for your tether.
Oh, thank you, ma'am.
You're all set.
Mm-mm, sorry.
Not at this time.
You can later, mom. I'll get out today. I love you. Thank you, ma'am.
You're welcome. Let's see, they put Davis on, is Rhodes downstairs? Joshua Road?
Yeah, Kent County, right?
Yep, I think that's the last one for the morning.
Did we do,
Unless I missed something.
did we do Bermudez?
We did not do Bermudez. Is that a sentencing?
Yeah, that's-
No, we didn't do me either.
Or me.
P Tenor.
You think I don't know? That's what you all get for staying into the judicial business. I am handling jail. I did not ask any of you all to unmute and tell me that I didn't do you. I know I didn't do you. You're sitting on Zoom waiting for your case to be called. Your attorney can only handle one case at a time. You can bring Rhodes, we'll do the 17th last.
Gotcha.
Okay, and then Davis is on. What are we doing with Davis?
Your Honor, it is my understanding that Mr. Davis would like to plead on all
All the files?
of.
I only have one file.
He
Got
has
another one.
On my docket today?
Not today. Remember, Your
the
Honor.
contempt and the pretrial
Oh, okay.
matters, Your Honor.
Oh, you can recall, he had another matter which I wrote a motion on, which he got another case with that same victim, another victim.
Oh,
He has like 4 or
yeah.
5.
Got it. Well, we're only gonna address this one today. So we gotta possibly do Judge Buchanan stuff. So I've been told he's having a trial. He's gonna plead to the charge and the bond